Hi all, welcome back to HM Commerce Education. This is CA Mani Chandana. Students, I'm really sorry for the previous video. Um, Due to some technical error, the voice clarity is not up to the mark. Uh, I don't know the probable reason for that, but I've heard it myself. I think it's manageable. So just let me know if you require me to record it again. Um, Please let me know in the comment section, or you can message me on HM Commerce Education. If you're okay, like if you're at least okay with the video, please message me that as well, uh, because I should be sure that you all are understanding that particular topic. If not, also please tell me, so that I'll be able to I will record for you all again. I will re-record that for you all again. Please, anything it is, please let me know. Okay, please. But sorry for that. Okay. Um, yeah. So let's continue. We have to start with the classes of companies under the Act, right? Okay, great. Fine. So, okay, come to page 466. For the students who have my material, those who have purchased my material, um, please come to page 466. Right? Okay, fine. Yeah. The growth of the economy and increase in the complexity of business operation in the corporate world has led to emergence of different forms of corporate organization. To regulate them, the Companies Act 2013 has broadly classified the companies into various classes. Okay, let's see what are the companies, different type of companies. Okay, see, a company may be incorporated as a one-person company, private company, or a public company, depending upon the number of members joining it. Okay, so depending on the number of members, a company may be a one-person company, a private company, or a public company. Next, it may either be an unlimited company, or may be limited by shares, or limited by guarantee, or by both. So this is based on liability. This is based on liability. Yes, based on liability, it can be either unlimited company, or company limited by shares, or company limited by guarantee, or company limited by shares and by guarantee, that is by both. Okay, fine. On the basis of control, the companies can be classified as associate company, holding company, and subsidiary company. Fine. The other forms of classification of companies are foreign company, government company, small company, dormant company, nidhi company, and company formed for charitable objects. See, each company will be learning in detail. Okay, this is just an introduction to you all. Okay, so based on the number of members, you have one-person company, private company, you also have a public company. When it comes to basis on liability, you have company limited by shares, company limited by guarantee, and unlimited company. Then on the basis of control, you have associate company, you have holding company, you have subsidiary company. Yes, the other forms of companies are foreign companies, government companies, then what is that? A nidhi company, dormant company, small companies, and companies formed for charitable objects. Okay, fine. Let's get into each one of them. Okay, ready, everyone? Yes, ma'am. Okay, so let's start with classes of companies under the Act. Classes of companies under the Act. Fine. Let's read. Page number 466. Students who have my material, page number 466. Right. The growth of the economy and increase in the complexity of business operation in the corporate world okay. The growth of the economy and increase in the complexity of business operation in the corporate world has led to emergence of different forms of corporate organizations. Yes, to regulate them, the Companies Act 2013 has broadly classified the companies into various classes. Okay, let's just read what all are there. Okay, a company may be incorporated as a one-person company, a private company, or a public company, depending upon the number of members joining it. sorry, okay, depending upon the number of members joining it. Okay, depending number of persons, one person company, private company and public company. Next, this is based on liability. Based on liability, the companies are classified into what, ma'am? Unlimited company, limited company limited by shares, or limited by guarantee, or by both. So based on liability, the companies are classified into unlimited company, company limited by shares, company limited by guarantee, or by both, meaning company limited by shares and guarantee. Okay, fine. Next, on the basis of control, on the basis of control. Previous one was on the basis of liability. Okay, basis of control, companies can be classified into associate company, holding company, subsidiary company. Yes, the other forms of classification of companies are foreign company, government company, small company, dormant company, nidhi company, company formed for charitable objects. Ma'am, again, see, children, is just it's just introduction to all kinds of companies. Each and every company will be doing it in detail. Okay, very good. On the basis of number of members, companies are classified into one-person company, private company and public company. Next, on the basis of liability, companies are classified into companies limited by shares, company limited by guarantee and unlimited company. Next, on the basis of control, on the basis of control, the companies are classified into holding company, subsidiary company and associate company. Next, the other forms of companies being foreign company, government company, nidhi company, dormant company, small company, companies formed for charitable objects, etc. Okay, fine. Let's start with the first, on the basis of liability, that is company limited by shares. Company limited by shares. Okay. Company limited by shares. Very good. Let's read. Okay. Section 222 of the Companies Act 2013 defines that when the liability of members of a company is limited by its memorandum of association to the amount of unpaid capital, yes, on the shares held by them, it is known as company limited by shares. Man, we know this, but we don't know where. Have we all dealt with this particular concept? Yes, you all know. What is that? Where did we learn? If you have revised just a second, if you have revised just like this, you'll know where you have studied this. Where? Features of the company, limited liability, didn't we discuss? Yes, we have discussed, right? So what did we learn there? The liability of members will be limited to the nominal amount or the face value of the shares held by them. Not even a single rupee can be asked in excess to the nominal value of the shares. Yes or no? Yes. If, say, for example, what are they trying to tell? See here, the liability of members of the company is limited by the memorandum of association to the amount unpaid on the shares held by them. Okay, it's correct only. To the amount unpaid on the shares held by them. Yes, right. Meaning what? Say, for example, the face value or the nominal value of the share is rupees 10 and called and paid up value is, say, for example, rupees 7. Yes, called and paid up is, for example, rupees 7. What is the maximum amount which can be called from the members of the company is only the unpaid amount, that is rupees 3. This is the maximum amount that the members will be what? Asked to pay. This is the maximum amount of liability. If the members have paid this also, say for example, the face value is 10, called and paid up is also 10, called and paid up is also 10. What is the amount which can be called from the members? Nothing. 0. 0 is the amount which is unpaid on shares. So that is 0 is the liability of members if they have paid the entire nominal value of the shares. Clear? Very simple. What else is there to explain in this particular topic, man? Nothing. Yes or no? Yes. See, next, let's read. It thus implies that for meeting the debts of the company, the shareholder may be called upon to contribute only and only to the extent of amount which remains unpaid on his shareholdings. So, in case the company is not able to meet the debts of the if the company is not able to meet its debts, the maximum amount that it can call from the shareholders of the company is only the amount which is unpaid on the shareholdings. Yes, his separate property, meaning his own personal assets, can it be attached? No, it cannot be attached. My personal assets cannot be attached. Getting my point? See, his separate property cannot be encompassed to meet the company's debt. Company's debt where my debt, my assets where you cannot take my car, you cannot take my jewelry. No, I am not giving you. Getting it? Yes or no? Yes. Next, it may be worthwhile to know that though a shareholder is a co-owner of the company, read it again. The shareholder is the co-owner of what? Co-owner of the company. He is not the co-owner of the company's assets. Very important. He is the co-owner of the company because he holds a share of the company, shares of the company. So he is the co-owner of the company. Co-owner or owner. If other owners are there, he will be a co-owner. He is only the owner of the entire. He holds all the shares of that particular company. Means he is the owner of the company. Getting my point? He's the owner of the company. He is not the owner of the company's assets. Owner or co-owner. He is the owner or co-owner of the company. He is not owner or co-owner of the company's assets. Getting it? Yes, my children? Yes. Good. Very good. The ownership of the asset remains with the company. The ownership of the asset remains with the company because of its nature as a legal person. Now you all know features of the company. We all have discussed very well. You know everything. Then what is there here to learn? Simple, no? Yes. The extent of the rights and duties of a shareholder as a co-owner is measured by his shareholdings. What they are trying to tell you is, you have more number of shares. You have more stake in the company. So your rights and duties, your rights increase when you have more number of shares in the company. Yes, it is measured. See, the extent of rights and duties as a shareholder, as a co-owner, is measured by his shareholdings. It is measured by his shareholdings. If you have more shareholding, obviously you have more rights. If you have less shareholding, you have less rights in the company, not with the company's assets. Company's assets are different, and if you are the owner of the company, you're not the owner of the company's assets. Your rights and duties as a shareholder, as a co-owner of that particular company, is measured by your shareholding. You have more than 50%, obviously you'll have more control. You have less than 50%, you have less control. That's all. What is that? It's okay. Fine. Okay, next. Company limited by shares. Done. Yes. Yes, children. Next, company limited by guarantee. Company limited by guarantee. Section 221 of the Companies Act 2013 defines it as the company having the liability of members limited. Again, liability of members is limited. It is limited or unlimited? It is limited by the memorandum of association to such amount as the members may respectively undertake by the memorandum to contribute to the assets of the company in the event of it being wound. Simple. What is that? They are telling that whatever you have agreed in the memorandum, whatever you're telling in the memorandum, what is memorandum of association? What is article? You will learn. Okay, but these are nothing but company related documents in which there are so many clauses. Okay, you will have a capital clause, you will have name clause, all that will come in that. Whatever you are telling, see, this much is the amount I will give if the company wounds up. This is from my side, I will give 10 lakh rupees if the company wounds up. That is written in the memorandum of association of the company. So that's all. Only that much you have to contribute. Not even 1 paisa extra you'll have to contribute. Understanding? See, now you read. It defines it as the company having liability of members limited. Yes, limited by the memorandum. Memorandum meaning memorandum of association. It is a company document, okay, in which everything is written. Okay, to such amount as the members may respectively undertake. There are so many members. Member A will tell, I will contribute 10 lakhs. Member B will tell, I'll contribute 50 lakhs. Member C will take, I don't have duddappa, I'll contribute only 1 lakh. Everyone, yes, respectively undertake by that memorandum, meaning in that memorandum, whatever they have undertaken to contribute to the assets of the company in the event of its being wound up. If the company closes or liquidates, or if it winds up, we will contribute so much. Company member A will contribute so much, member B will contribute so much. That's all. Understanding? Yes, yes, ma'am. Okay. Thus, the liability of a member of a guarantee company is limited up to a stipulated amount mentioned in the memorandum. Artha aitu? Yes, everyone? Yes, ma'am. Artha aitu. Artha aita meaning, did you understand? Artha aitu meaning, yes, we have understood. Okay. This also you understood. Very good. Okay. members cannot be called upon to contribute beyond that stipulated amount. Understanding? See, they're telling, if you have undertaken to give a certain amount, say for example 5 lakhs or 10 lakhs or 10 crores or whatever it is, the members cannot be called upon to contribute more than that amount which you have undertaken. Simple. Again and again they are writing the same thing. Yes, see, okay, now here it is important. Now this is important. Okay, what is that? The common features between guarantee company and the company having share capital are, the common features they're talking about. One is legal personality. What is that? Company different, members different. Yes, yes or no? Company different, member different. Next, limited liability. Next is the limited liability. Company limited by shares. Company limited by shares. Company limited by guarantee. Company limited by shares. Company limited by guarantee. What they're trying to tell you, the liability of members is limited to the unpaid capital if it is limited by shares, or to the nominal value of the shares if it is a company limited by shares. So if it is a company limited by guarantee, again the liability of members is limited to the amount they have guaranteed. Yes, yes, yes ma'am. Okay. In the latter case, the members' liability is limited by the amount remaining unpaid on the shares. Which one is this? Company limited by shares. Yes or no? Yes. Which each member holds. Both of them have to state in their memorandum that members' liability is limited. Yes or no? In the memorandum of association, we are telling that the members' liability is limited. Limited either by the unpaid amount on shares, or limited by a amount guaranteed by the member. But both they are limited. Liability is limited. Understood? Yes. However, the point of distinction between these two types of companies is that in the former case, former andre eno guarantee company appa illi. Former meaning, see here they would have given, see this one, here they're talking about guarantee company, next they're talking about company having shares. So here the former case meaning the guarantee company, the members may be called upon to discharge their liability only after commencement of the winding up. Only after commencement of winding up, which means if the company is running, its business, now it is not the process of winding up has not started. Now, can the members be called upon to pay their guaranteed amount? No. The members may be called upon to discharge their liability only after commencement of winding up, and only subject to certain conditions. Getting it? But in the latter case, which one is that? Company limited by shares. Company limited by shares, they may be called upon to do so at any time. At any time during the company's lifetime or during winding up. Meaning, when the company is doing business, even at that point of time, the members may be called upon to pay the remaining unpaid capital of the shares held by them, or during winding up. During the company's lifetime or after the death of the company, both times the members may have to be may be called upon to pay the unpaid capital. Yes, in which company having share capital. But in case of company limited by guarantee, only and only during winding up. Yes, understood? Yes, see, it is clear from the definition of guarantee company that it does not, okay, that thing is fine. This is the next paragraph. Okay, it is clear from the definition of the guarantee company that it does not raise its initial working funds from its members. Therefore, such a company may be useful only where no working funds are needed, or where these funds can be held from other sources like endowment, fees, charges, donations, etc. So what they're trying to tell you is such guarantee companies, usually they are these are companies where we are not collecting any funds from the members at the time of when we are running the business. Yes, we are collecting money only if the company closes down, only if the company liquidates. Getting my point? So in what kinds these companies we'll have to form is that when we do not need any initial working funds, or when there are no working funds needed. Example, ma'am, when say for example, if the or where the funds can be held from other sources like endowment, fees, donations, etc. They are getting donations from so many people. At that point of time, you don't need capital from the members. At that point of time, you can open a guarantee company. or whenever you don't require any working funds. One, when you don't require any working funds. Second one is that when these funds are we can get funds from other sources like fees, charges, donations, etc. Clear? Guarantee company. Yes, ma'am. Okay. Let me just check the video. Okay. Fine. Good. Next, in Narendra Kumar Agarwal versus Saroj Malu, the Supreme Court has laid down that the right of a guarantee company to refuse to accept the transfer by a member of his interest in the company is on a different footing than that of a company limited by shares. The membership of a guarantee company may carry privileges much different from those of the ordinary shareholders. See, again, children, this particular case law, this is not there in your book. The facts of the case are not there in your book. Just for your information, I'll just tell you the facts of the case. Just I'll explain you in a short period. Well, there was this one person called Narendra Kumar Agarwal. Okay, he was a member of a association. This is called Mugdha Stock Association or something. It was a guarantee company. Basically, he was a member of a guarantee company, and he wanted to transfer his interest. He basically wanted to transfer his interest as a member in that particular guarantee company to Saroj Malu. To Saroj Malu. But the guarantee company refused. Because such transfer was not allowed, was not written in the articles of association of the company. You will not understand that much, but just try, just give it a try. Okay, that guarantee company refused, but because it was not there in the articles of association of the company. So it said, no, you cannot transfer your asset, sorry, not asset, the shares of the company. Okay, because it is telling that this company is not a company limited by shares. See, here you can read that the right of guarantee company to refuse to accept the transfer of member of his interest is on a different footing than that of a company limited by shares. Company limited by shares, yes, you can transfer. For example, today I am the shareholder, tomorrow some other person can be a shareholder. But in case of guarantee company, it's not like that. So it is different. That is what they are trying to tell you. You don't have this in your syllabus, don't worry. They're just telling it is on a different note when compared to the limited or company limited by shares. Yes, getting it, the membership of a guarantee company may carry privileges much different from those of the ordinary shareholder. So if you are a member of the guarantee company, your privileges are much different than that of the normal shareholders or members of the company limited by shares. So there is certain differences which they are trying to tell you, but it is not of that importance. Okay, fine. But just for your information, I've told you what happened in this particular case. Okay, good. Good to go. So we have learnt about company limited by shares and company limited by guarantee. Next, unlimited company. The last one, unlimited company. Ma'am, what is this? Okay. Section 2, subsection 92 of the Companies Act 2013 defines unlimited company as a company not having any limit on the liability of its members. The name itself suggests unlimited company. So the liability of the members of such company is not limited. It is not limited, not having any limit, no limit, not having any limit on the liability of its members. Meaning what? Meaning their personal assets also can be attached. Okay. In such a company, the liability of a member ceases when he ceases to be a member. Meaning, if I am a member of an unlimited company, I am a member of a unlimited company, my liability will stop. Cease meaning stop. I will not have any liability only when I am not a member of that particular company. I will not have any liability only as a member only when I am not a member of such company. So it will stop when I stop, my liability stops when I stop to be a member. See, in such a company, the liability of a member ceases when he ceases to be a member of the company. Okay, okay, good. Yes, okay. See, children, okay, wait. Okay, fine. The liability of each member extends to the whole amount of company's debts and liabilities, but he will be entitled to claim contribution from others. Now, what do you mean by this particular line? See, what they're trying to tell you is the liability of each member. Say, for example, there are 5 members. There are 5 members. Okay, extend the liability of each member. Extend to whole of the company's debts. Extends to whole of the company's debts. Ma'am, what do you mean by that? What do you mean by that? Say, for example, company debt is 10 lakhs. Company's debt is 10 lakh. Now, this person's liability extends to whole of this 10 lakhs. So, on his head, there is a liability of 10 lakhs. Okay. The liability of each member extends to the whole amount of company's debts, but he will be entitled to claim contribution from other members. Meaning, he will have to pay 10 lakhs. Again, he is eligible to claim contribution from the rest of the members. Getting it? Yes or no? Yes. Okay, my battery is low. The laptop battery is low. Okay, let's still continue. Okay, the liability of each member extends to the whole amount of company's debt. Say, for example, the company's debt is 10 lakh. He is liable for the whole amount. Yes, but he will be entitled to claim contribution from the other members. Yes, simple. Yes, ma'am. Okay. In case the company has share capital, meaning the unlimited company also has share capital, then the articles of association must state the amount of share capital and the amount of each share. They're trying, if this unlimited company has share capital, it's possible. It is possible. Yes, then the articles of association must state the amount of share capital and the amount of each individual share. Okay, so as long as the company is a going concern, the liability on the shares is the only liability which can be enforced by the company. Okay, this is very important. It is very important. Now, unlimited company, limited by shares. Also, it has share capital. Now, see, as long as the company is going concern, meaning what? The company is going concern, meaning it is running the business. Good. It is not wound up. It is going concern, meaning what? You would have learnt in your accounts. Going concern. It's still running. It is still running. The business is still in existence. Then the liability on the shares is only the liability which it can be enforced by the company. Meaning personal assets cannot be attached. Only the value of unpaid capital can be recovered from the members of the company. The creditors can institute proceedings for winding up of the company for their claims. The official liquidator may call the members for their contribution towards the liabilities and debts of the company, which can be unlimited. Okay, let me first explain to you clearly, make this concept a bit more clearer. Okay, see, in case of unlimited company and limited by shares, now when the company is doing its business, when it is going concern, it has not liquidated or it has not wound up. Avaga, at that point of time, you cannot ask anything more than the unpaid capital from the members of the company when the company is doing its business, when it